Okay, so good afternoon, good morning, good evening, everyone. It's my pleasure to welcome you today on behalf of the United Nations Institute for Training and Research, as well as the USTICON NGO. My name is Liliana Canedas. I'm part of UNITAR's Division for Multilateral Diplomacy, and I will be moderating this webinar. I'm delighted to discuss today the complex question of whether international criminal justice is in crisis with two renowned experts. Olga Kavran, the founding director of USTICON, the first non-governmental organization focused on communicating justice. She's also a former spokesperson for the prosecutor of the ICTY and head of the outreach and legacy at SDL. It's also a pleasure to have Dr. Mark Drumbl with us today, professor of law and director of the Transnational Law Institute at the Washington and Leone University, whose extensive work on transitional justice has been relied upon by courts and who has also served as an expert witness and consultant with the UN and OSCE. Thank you both of you for being with us today. I would like to take the opportunity to inform everyone that on the 21st February, we are launching the Executive Diploma on International Criminal Law and Transitional Justice, which you might be also interested in, and which comprises also a session dedicated on the current perceived crisis of international criminal justice. So should you wish to know more about this topic after the webinar, please don't hesitate to register for our executive diploma. It will give you insights from academics, policymakers, but also international experts, and you will also have the opportunity to expand your international network. The program is going to be taught via Zoom, as you might all guess, and it's going to be taught during a period of 5 weeks, each week covering a different topic, and also including case studies and skills component. And now back to the reason why we are here today. Before I give the floor to our experts, I would like to let everybody know that this webinar will be concluded with a Q&A. But should you have any question before that, or should you wish to raise any remarks, please feel free to write those in the chat before the end of the webinar, or use the Q&A function. And finally, Olga and Mark, you have the floor.
Thank you. Thanks very much. Mark, do you want to start us?
Sure. So good afternoon, good morning, good evening. I guess good everything to all of you who have taken a bit of time to join us in our sort of ice-breaking conversation with regards to the intersectionalities between international criminal justice on the one hand and this notion of crisis on the other. And I think this entire conversation is a bit of a primer, a bit of a foreshadowing for this executive diploma, as Liliana had mentioned. And what we hope to do here is not only have a conversation in the here and now that's self-contained about international criminal justice in crisis, but also look ahead a little bit to some of the opportunities that this particular executive diploma programming might offer, so as to add not only to knowledge bases, but also to offer a space and a place to take that base of knowledge and push it into new and different directions. I think a good icebreaker, though, is to talk a little bit in an introductory sense about the two major terms at hand. One is, of course, international criminal justice. And I think we are going to understand this terminology in a fairly broad and inclusive sense, meaning that we're going to think about international courts, of course, the juridical function, but also the juridical function at the national level. And also, I think we'd probably like to talk about institutions that transcend well beyond courts, other methodologies to try and obtain justice, reparative approaches, truth commissions, commemorative ceremonies, perhaps if we even get sufficiently adventurous and have the time to talk and think about things like art, theater, broader public policy, all as mechanisms in which law can play a role, but also be very supportive. And then the second term at hand is crisis. And this is a term that I've actually thought about a little bit. Crisis is a term that's used for a lot. It seems that we're perpetually living in some sort of crisis or crises. They're ongoing and redounding and bouncing back and forth. And I think generally in modern discourse, certainly in English, and as an English speaker, I'm susceptible to vocabularies and norms in the English speaking world. Crisis isn't a good term, right? It's often seen histrionically, hyperbolically, the sky is falling. And I think I'd rather avoid that kind of an understanding of crisis as one where we panic, throw our hands up and sort of say, well, there's nothing we can do, or just feel overwhelmed. And it's very interesting to me in a linguistic sense how the word crisis in the English language, I also speak French, and I think in French there's a similar dynamic. It's interesting to me how this term over and through time has become associated with this histrionic negativity. Because really the origins of the term crisis, if you go back to ancient Greek, the term crisis in the ancient Greek context really means something slightly different. It actually refers to the idea of a turning point, the idea of a watershed, the idea of a point of inflection, a choice, an election, a decision-making. And what I like about the original usage of this particular term is that it suggests a more positive, optimistic, and active voice to those individuals who are involved in the process that's being scrutinized, in our case here, international justice. And I prefer this more vivacious, active, forward-looking posture to the idea of crisis as one in which we're all passive, we're all disempowered, and we're all vulnerable and susceptible. So by way of introduction, as a general framing, I think I'd simply like to repeat much more briefly what I've said at greater length. First, we're going to take a broad, holistic view of justice. And secondly, we're going to try to approach this with some verve, some energy, some positivity. Anyone who's read anything that I've ever written knows that I'm a bit of a skeptic of international justice interventions, certainly in the legal context, but I'm a big believer in justice. And I think as a believer in justice, what I would like to do in this space is think out of the box in an engaged fashion, speak directly, and try to build a better future instead of just hide away hysterically. All right, so that's sort of just a little bit of a preface. And Olga, can I bounce it back to you?
Yeah, sure. Yes, indeed, I would absolutely agree with the idea of taking the term crisis in a broader sense, and a much more positive sense, meaning that it is a call to action. Some writers have also argued that international law in general is in a perpetual state of crisis. And that in fact that gives rise to new norms and new ideas, and that state of crisis defined in that sense is in fact some sort of a crucible for future development and future improvement. Perhaps it's worth maybe mentioning just very briefly for our audience, when you mentioned that we're going to speak about international criminal justice, again, I agree with the notion that we're in fact going to be speaking about perhaps more about what is now known as transitional justice, which of course includes international criminal prosecutions and national criminal prosecutions, but also includes truth commissions, as you mentioned, includes reparations programs, includes gender justice, security system reform, and various memorialization efforts. I would also agree with you that it certainly includes movies, for example. And we see very recent examples of exactly that, where I come from, which is the former Yugoslavia, where unfortunately, even 30 years after the war, we've got all kinds of rhetoric and denial of crimes and denial of genocide and denial of various things that have occurred. We also have a movie which is recently has come out of Bosnia about the genocide in Srebrenica, which has caused a tremendous amount of debate. And I would argue that that debate is every bit as important as any other process of facing the past in terms of crimes that have been committed. And I would argue also that that movie has probably reached audiences no ICTY prosecution ever would have reached in the same way. So yes, absolutely. I think justice happens in different ways and in different places, sometimes entirely unintentionally. I would also say that because a lot of people simply, make a movie to make a movie, not necessarily to achieve the goal of reconciliation or facing the past and so forth. So that's something that's very interesting to ponder. In terms of international criminal justice and transitional justice and its development, some have argued that people see Nuremberg as some sort of a creationist moment, if you will, of modern international criminal justice as we know it. And certainly it can be looked at in that way, but it can also be looked at as something that would not pass muster at the moment under the laws of international human rights, because you could successfully argue that these were military tribunals which had the death penalty, did not allow for appeal and so forth, things which would simply be unacceptable, particularly in the international legal order today. However, Nuremberg certainly did set, and the military tribunals in the aftermath of World War II certainly did set a precedent that is a very important precedent in terms of principle for dealing with atrocities. During the Cold War, unsurprisingly, there was very little by way of international criminal justice. There was very little agreement, even though there were many wars and many atrocities that were committed in the interim. It wasn't until the shakeup, if you will, of the then political world order with the breakup of the Soviet Union and so forth, that there was a different mood, if you will, and unfortunately also accompanied by the horrific crimes committed in Europe for the first time after World War II, which galvanized public opinion and consequently the politicians to move in the direction of creating the first ad hoc international criminal tribunals. Of course, the first one was the ICTY in '93, and then followed quickly by the Rwandan tribunal to address the atrocities, the genocide committed in Rwanda in 1994. In the next 10, 15 years, we saw a proliferation of various ad hoc tribunals. And we also saw the creation of the first permanent international criminal court, right? Which the Rome Statute, of course, was signed on in 1998. And then the court itself opened its doors in 2002 after the initial 60 ratifications, which were required for the court to begin work. And at that point, I think that this a lot of enthusiasm and hopes and expectations were placed in the International Criminal Court, right? It seemed at the time that this was going to be the end all, if you will, the be all and end all of all international criminal justice efforts. And of course, no institution can possibly live up to such expectations at the international level, not the ICC either. And I think that when we look at a lot of the criticism that is leveled at the International Criminal Justice Project as such, a lot of it stems from expectations, which are, in my view, unrealistic to a certain level, especially because the ICC has limited jurisdiction, limited by the states that have ratified the statute, limited by the temporal jurisdiction, which only kicks in from July 2002 and so forth. Various other, not least of which, of course, the limitations are in resources, which are not endless, and so forth. So I think that the management of expectations is one of the biggest issues when it comes to achievements of any international criminal justice or transitional justice mechanism. While this was all going on, or I should say even before the creation of the ICTY in the 80s, what we saw is a number of truth and reconciliation commissions, which had been formed in different parts of the world and which continue to be active, or rather to be formed in other parts of the world as well, in parallel to these developments. We have also seen the Gacaca courts, if I'm pronouncing that correctly, in Rwanda, which is a form of very local justice of a very different nature than the notions of international criminal justice and very legal proceedings that take place inside international courtrooms. We have also seen something that is very important as well in where I come from, again, the former Yugoslavia. We've seen a number of national proceedings that have taken place to deal with atrocities committed in the 90s. Now, of course, if you do a thorough analysis, people will agree that's perhaps not as many as should have been done and perhaps not as well as they could have been handled. However, we need to keep in mind that had it not been for the ICTY in the first place, and the transfer of knowledge and capacity building, which is another thing we can discuss as a consequence of these international criminal justice efforts, there never would have been any proceedings at the local level. Of that, I'm pretty sure. And so it's interesting to look at that as well. So these are just some broad strokes of some of the things that I think we can think about and discuss, and a broad stroke of what we need to, or what we can be looking at. And this is all the things that we are actually going to look at in the program of the executive diploma, precisely because international criminal justice is one of the elements, and it's in fact a broader story of transitional justice and how it has played out around the world. We can also speak about later on about the universal jurisdiction cases and so on. There's a lot actually to dig into and unpack.
Yeah, you know, Olga, one thing that I found striking and important in your remarks, again, not necessarily as an entry point because we're in, but as a bit of an intermediate observation, is the idea of expectations. And I think it's very important to think more critically about that. I think if we think of institutions such as the International Criminal Court, and I think antecedent ad hoc tribunals as well, although a bit less so, I think there's an entire rhetoric that has emerged, a rhetoric of salvation and incredible responsibility. So many expectations have been put on the International Criminal Court, and the International Criminal Court has put those expectations on it in part, and on itself in part, because of a search for meaning, a search for existential justification. And I think what's ended up happening, and Darrell Robinson, who's a Canadian international law professor, has written on this, and he's used a good adjective to describe the expectations the International Criminal Court has put on itself, and that's the term altitudinous. It's not a word that one uses too often in English, but it's a neat word, and I like words, and I like that word. And it really reflects the idea of altitude, loftiness, height. But once you start using those words, inevitably, you might just simply turn into Icarus and begin to fly too close to the sun, begin to try to do too much beyond the capacity of what a court can actually do or accomplish. And I think this is one of the major starting points of any conversation that, to some extent, I think the crisis the International Criminal Court might be in is in part self-inflicted, from creating, generating, and imposing these altitudinous expectations on itself. You know, sometimes when I think about the court, it's an odd analogy, but sometimes I think of a penguin, for example, on the ice. This animal that we all really love, walking on its flippers like little penguin shoes, and making its way. And as penguins walk, they often belly dance a little bit. And we all want the penguin to make it. We all want the penguin to keep on waddling ahead and to go where it goes. But the point of the matter is, a penguin really can only walk on ice and swim in the sea, and even struggles at that at times. And yet what we see with the International Criminal Court is trying to do so many things that a court ordinarily shouldn't be expected to do, namely end impunity, promote all kinds of reparative justice, all kinds of social justice, promote gender equality, promote inclusiveness, have this incredible transformative output, but it just can't do it alone. And I think it's not only outreach to the court that's important in terms of liaising with afflicted populations, but also I would suggest more modesty, more placidity, more perspective, more maturity, more emotion, and a bigger embrace of alternate methods of justice. And that's a mindset that has to change, in my opinion. And this point of inflection, this point of crisis, shouldn't be seen as a breaking point, but perhaps a fork in the road for the International Criminal Court not always to see itself in all caps and all capital letters, but perhaps also sometimes a little bit more modest in some ways. So Olga, I'm not sure if you've done a lot of work inside the tribunals. I'm just looking from outside, but that's what I see. Do you see something similar?
Yes, I do. And in fact, because I've been on the inside for so long, I can also talk about the transformation within, among some of the people, at least, in terms of understanding what's important, right? So at the ICTY in the early days, we were all about talking about reconciliation and contribution to reconciliation. And we insisted that this is one of the goals and one of the achievements, if you will, of the tribunal. I think that, all of us who did genuinely believe that back at the end of the 90s and early 2000s, informed by our own experience from within these institutions and what they have actually realistically been able to achieve, but also observing what's happening in the societies over which they had jurisdiction afterwards. Our own expectations have obviously changed. Their own view has also changed because it's informed by the information we have obtained in the past, in the developments and the evolution in the past 20 odd years. So, for example, while, I would include myself among the many who are still very much believers, as you said, in the justice project, we now have different ideas of how it might best be achieved. So, whereas many of us would have thought that the criminal prosecutions are the end all and be all, most now realize that clearly, alone and independent of any other processes, they have no effect except, well, not that they have no effect, let me take that back. They have a very important effect, except only as catalyzed through research, for example. So some people will be publishing books on what the ICTY has established, and these books will be hopefully read by some other people and so forth. But at the societal level, they will not make a difference in today's, today, for example. And we have seen also that with Nuremberg. If you look at, there's a brilliant documentary that people might want to look at, a very long one from 1975 called The Memory of Justice, done by a German director. And it's a documentary about the impact of the Nuremberg trials, the understanding of Nuremberg trials 20 years after the fact. In Germany. And it's just fascinating to see and to hear ordinary people from that period of time talking about their perception, how they lived the whole legacy of the wars and of the trials and so forth. So you see that the situation we find ourselves in today is not unique. It's the human condition. Some people will always be the so-called early adopters of a particular idea, and others will never come to the party, as it were, and will never accept these things immediately. So there's, but to go back to the expectations, yes, absolutely. The criminal justice processes must be seen as one tool in a box of many tools. And even the processes themselves, as they are now conducted, suffer from a lot of flaws, which have been identified and commented on by practitioners and scholars alike, but perhaps not sufficiently analytically. And what I mean by that is I think that this field would definitely benefit from input from external input from other fields, such as sociology and anthropology and psychology and victimology and so on, all connected, obviously, but they could use their own methods and means of analysis to give a more informed opinion, if you will, or analysis of the impact of all of these processes. For example, we take for granted that if somebody is held accountable in a criminal justice context, that this will somehow right a wrong. Okay, we take that for granted, and I'm not going to argue against taking that for granted, but I think that it's worth looking into what do we actually mean by that? What does it mean for a woman in Srebrenica who has lost every male member of her family, that some general that she had never met, except she would have seen him in the media, is held responsible and serving his sentence in some arguably comfortable prison in Western Europe, while she's struggling to make ends meet on her own in a rundown house without, sufficient heating in the middle of winter. These kinds of questions are very relevant questions. They're very relevant questions. And again, this is not to say we shouldn't have criminal prosecutions or these people should not be in prison. Absolutely, they should be if they have been convicted of these crimes. But just to say, what else should we be doing as a society and how that fits into the transitional justice? What is transitional about transitional justice? Is it a project of transformation? And then how widely do we want to approach that transformation? Are we looking for, when we're looking at one typical limitation of criminal processes and criminal trials is that, of course, they can only concern themselves with the individuals who have been indicted. And it's always individuals, because that's another thing that we can discuss about international criminal justice, is it's always about individuals, whereas we know that the nature of some of these crimes is such that they cannot possibly be committed by individuals alone. Genocide cannot be committed by an individual. It can only be committed by a large number of individuals acting in concert somehow. So that in and of itself, I'm just throwing a lot of questions out there and a lot of things that can be debated. So the main limitation, again, on the individual level is, so we're talking about somebody who was indicted, or people who were indicted, the crimes that are that they have been suspected of, or the allegations against them. And this is the only thing that the judges will look at. They will not look at any other crimes that happen to have happened in the area that are not relevant to the criminal charges in front of them. They might not look at the history of the accused. And you, Mark, have written about that and can speak to that, about the child soldiers who end up in the dock, right? They will look at, what they will look at is very, very limited by the criminal proceedings themselves, by the rights of the accused, by the rules that guide the process, and so on. So these are also the limitations that play into ultimately limiting the impact of international criminal justice on its own. That is why it is crucially important to understand that it's absolutely necessary to add other elements to the mix. I will mention one egregious example, which did happen, in fact, where charges of rape were not raised in an indictment against an individual. I'm not going to go into the technicalities of why this didn't happen. And yet, some of the witnesses who came to testify to prove that he happened to have been in a particular place, which would put him in the place where other crimes had been committed, testified to his presence because he was raping them. And so you have this completely absurd situation where a victim is testifying in court about something that happened that the person cannot be held responsible for because, again, because of various reasons, which, again, too much detail to go into, the allegations were not included in the indictment. And these are the kinds of absurdities that can happen. Again, this is an extreme example just to illustrate the point. But these kinds of things can happen. So criminal prosecutions accompanied by truth and reconciliation efforts, if those are appropriate in the local context, accompanied by reparations, accompanied by, again, security system reform, if they're relevant in the local context. What I'm trying to say is that we need to look at each context separately to see what mix of efforts would actually achieve the desired results.
Yeah, you know, it's interesting. In addition to some of these absurdities you pointed out, Olga, you mentioned this idea of being transformed. And I think a very important pre-existing question is even if we assume that there's transformation, who is it that is being transformed? What kinds of violences and what kinds of atrocities are falling within this lens? I see in the chat space a comment from Samuel, who's listening from Kenya, who asks whether international criminal justice's crisis has a connection with the effectiveness of the United Nations Security Council. And I think this is a very important question because it goes to the heart of the issue of selectivity. So the late Robert Cryer, who's quite a good friend of mine, wrote about 10, 15 years ago a book on selectivity in international criminal justice, recognizing that only certain kinds of jurisdictions ever fall within the spectrum, right, of international judicialization, either losers in war or in general, you know, places that can't really exert power against the centers of global power. So even the process of making justice becomes a manifestation of power. And here's another connection I'd like to make back to the idea of too much expectations placed on the ICC and the ICC placing upon itself. Let's be very frank. If we look at the docket of the International Criminal Court and the handful of successful cases that have been brought in what is now almost a 20-year period. I mean, this is no longer a child anymore, right? So this is a 20-year-old. The hallmark of successful interventions by the International Criminal Court have involved rebel leaders who have lost their rebellions, often against autocratic states. And in part, those particular unsuccessful rebellions have been referred to the International Criminal Court for judicialization. If you had an MBA degree, if you were a business person and you looked at where has there been a return on investment, where has the share value of the International Criminal Court appreciated and gone up, if you wanted to play Monopoly, board game with the International Criminal Court, you would want to land on the spaces of unsuccessful rebellions. That is the major area in which judicialization has occurred. So I think the International Criminal Court should just own that. The International Criminal Court has had a very difficult time bringing in powerful leaders. Forget about leaders in powerful places, even middling powerful leaders. Government-sponsored violences have really not been at the forefront of the capacity of the International Criminal Court. So instead, we have the LRA, we have Al-Mahdi, we have Lubanga, you know, we have individuals who are all part of that same group of rebels who lost, as political scientists would say. But that's not a bad thing. It's not a bad thing that that's the kind of justice that one can deliver. But I think one has to be honest about that, as opposed to this mantra of impunity ending I think the International Criminal Court should just be more honest about what it actually can and cannot do. And that greater honesty, I think, would open up more spaces for other methods of justice that go well beyond even our understanding of a legalized justice. And I think that's a very important starting point that I would also echo you on. I also think we have to be very honest about something else from a business perspective, once again, and that's just the numbers game, the demography. You know, if you look at some statistical analysis of who is really doing the heavy lifting of post-conflict justice, where are the numbers? Where are the people? Where are the interventions? It's not international criminal justice institutions. The vast majority, thousands and thousands and thousands of individuals face a justice process outside of the international criminal courts and tribunals. That doesn't mean the work of the international criminal courts and tribunals isn't important, but they get a disproportionate amount of attention. They get so much attention, and other institutions that do heavy lifting often do that work with much less attention. And I think there's a need for us to diversify what we look at when we think about justice. Well, philosophically, this is a problem of epistemology, right? From where is it that we think we know what we know about international criminal justice? And the first best answer, this principal source, the thing we think about the most often, are institutions in The Hague, these kinds of internationalized institutions. But if you look at it from a numbers game, they do very, very little. Say what you want about the Gacaca proceedings in Rwanda. The point of the matter is hundreds and hundreds and hundreds and hundreds of thousands of people went through those proceedings, as opposed to roughly 100 at the ICTR. And I'm hopeful that in the program, Olga, that together with Liliana, that you all are organizing, that there will be a space to talk about those places that don't form part of the knowledge base, to use my little rhyme from before, because they do a lot of work, a huge amount. And I think there are many lessons to be learned from there. I think we should kind of try to invert the dynamics. I'm thrilled to just see in the chats, I'm not very good at multitasking, or I'm an old guy. So, me trying to read a chat while talking and blah, it's a bit much. I can see a little bit, but I'm thrilled to see so many listeners from the global South. I'm thrilled to see so many people from really all over the world, because I also think there's a crucial need to inclusively diversify, not just who is listening, but who is speaking about international criminal justice. And hopefully that's also an important theme.
Yes, I absolutely agree with that. And I absolutely agree that we need more voices from other parts of the world. What we have done, for example, with the Lebanon Tribunal, is to try to assist in translating a bunch of stuff into Arabic, because even that will assist a lot more people, because you would be amazed, and you probably know this, obviously, as to the prevalence of all of these materials in the English language. Even people who speak French but don't speak English, which you would think is quite present in international law and international criminal law, is something like 20% of the literature, if that. And that probably is shifting in favor of English as we speak. So on the one hand, it's not a bad thing, because of course, English has become a lingua franca, and a lot of people around the world learn English because they want to be able to communicate with the rest of the world. I'm not even going to go into the linguistic debate, but there is something to be said for diversifying the language base of this a whole project. So, and we found that to be very important. And for example, believe it or not, There's only one textbook entirely in Arabic at the moment that I'm aware of on international criminal law, and that is Cassese's International Criminal Law, translated into Arabic some years ago. And this is, I mean, as one of the projects that we did as outreach at the STL. And as far as I understand, the translation is not perfect, but at least it's there for people to kind of ponder the terminology, because we're talking about, of course, something else that we haven't touched upon, and that is how dominated international criminal justice is by one major legal system in the world, and that is the Anglo-Saxon common law system. It's simply a fact. I don't think that there's something terribly wrong about that, but it's something to be taken into consideration when, for example, we try to communicate with people in other parts of the world as to what is being done, how it's being done, why it's being done, the technicalities of it, which are unfortunately very important, because that's the expressive side of all of these proceedings. This is what people see happening in court. And if they don't understand why it's happening in the way that it's happening, then they will think it's arbitrary. And so we come to, managing that part of the narrative as well, of how we go there. I want to say perhaps something about that which I'm particularly concerned with, which is how we communicate this, because I think that the lack of communication is also what you're addressing in your remarks, because it should go both ways, except that it doesn't really. And so, one limitation is of how these institutions and what they have done in order to make themselves understood and to communicate with the concerned publics. But then again, also with everyone else around the world that we want to kind of contribute to this, if you will, justice project in the broadest of senses. And there we have, very little involvement as compared to what I think it should be from many parts of the world, and particularly, as I mentioned, people where English is not necessarily as widespread and as widely used as it might be in other parts of the world. So these are all the challenges and issues that. Yeah,
and I would also just jump in on another point that I think we should also be honest about. I mean, I'm a law professor trained in the common law. I mean, I like law, but let's be honest, trials are boring. They really are. They're long, they're languid, they're slow, they lack emotionalities. Occasionally there's an outburst that gets some attention. But outreaching a criminal trial, particularly an international criminal trial that involves an extremely complicated evidentiary and documentary base, often just to prove something we know already happened, is really tedious. And, again, from a business perspective, if I was trying to sell justice, I'm not so certain that a 4-year-long criminal trial with lengthy pre-trial and interlocutory proceedings beforehand is the product that I would want to sell. So I think there's this frustration about outreach not working, but trials are really boring. Like, I've even brought law students to sit and listen in the Zog at international proceedings, in The Hague, and they're like, hey, prof, man, wow. That was a really boring 3 hours. And they're all law students in law liking this, right? So I'm not trying to be immature, or I'm not trying to regenerate the idea of a show trial, or, yeah, sure, I'm American. Hollywood has its limits. I'm not saying that this is what should be taking this over. But once again, I think we should be much more honest. And some of that is just intrinsic to the legal process. Like, even when you hit this zenith, this big moment, right? When the the verdict is announced, the theater of the trial is very muted. The judge has to speak slowly and dispassionately, neutrally. calmly. I mean, I don't want some judge to do a song and dance routine and be some, attention seeker. That's not good either. That belies the ponderousness and seriousness of law. But how can we outreach something that is so languid, so arcane, and so tedious, even to audiences who study this stuff and are culturally steeped in the very system of which you're speaking? So I think this is also an important dynamic. And I think if we look overall, from where have we learned the most about the tragedy of the human condition? From where have we learned the most about what happened? I'm not certain it comes from legal judgment. I think it comes from many other places. And I think this is something, once again, we have to recognize in law. We're really not the be all and end all. We can't be narcissistic. And there's two levels of narcissism. One is the fetishization of the international, when so much more law is actually in play. And then it's the fetishization of law generally. So I think these are crucially important sort of intermediate observations that are much more generalizable than simply saying, oh, well, this move could have been better, or certain crimes could be included, or how great is it that now cultural property, destruction is a war crime, how great is it that child soldiering, is now defined as a war crime internationally. I think there's a lot more about meaning and the lack thereof.
You're absolutely right. And going on from that point, or rather illustrating that point by, again, another example, which I find fascinating. So for a period of time, the Sierra Leone tribunal was hosting its proceedings in The Hague, because the Charles Taylor proceedings were, it was considered that it was not, for security and safety reasons, wise to do it in Sierra Leone, where the rest of the court proceedings took place, but rather in The Hague. And at that point, it was sharing its building with the STL. And so I was there when they were preparing for the testimony of Naomi Campbell, who very famously came to testify in The Hague. And there was a big debate amongst a bunch of people in both STL and the SCSL, who were sitting in the cafeteria. And so some people were of the view that it's an absolute travesty that we have 200 journalists and satellite cars and all kinds of things for those that one day or 2 days, I forget now, that she was testifying, and that the trial otherwise was more or less ignored, except for the opening statements, perhaps, at that point. And my argument was that that's not at all the case, because many more people around the world, by the thousands, have actually heard about the trial against Charles Taylor and the charges leveled against him, because every journalist who did come, who was a proper journalist, had to do a summary of proceedings as to why Naomi Campbell was there in the first place, right? And so there is that debate. I mean, and some people would argue, no, this takes this makes a circus out of criminal justice. And I would argue, well, no, if it's handled within reason, meaning that the tribunal is the one that's providing the footage or not letting cameras into the courtroom and making a circus in that sense, why not inform people who otherwise would not be informed about these proceedings? So there's that too. And again, we go back to talking about the expressionist value of these proceedings, which again is important, but not only about criminal prosecutions, about any of these proceedings. The people from South Africa will talk about how impacted they were listening to the testimonies of people who spoke in the proceedings of the Truth and Reconciliation Commission. And obviously that's just one example. And as I mentioned earlier, the movie that's generated a lot of debate locally in Serbia, where, by the way, it's forbidden even, is Quo Vadis Aida, is the movie that I'm talking about, has generated a lot of debate about the genocide in Srebrenica, which was committed in 1995. And these should not be discounted, and these should be included in our discussion, as you rightfully pointed out. But just going back to the issue of the actual institutions themselves, I know that you and I have slightly different views on this in terms of where we think the future of this will be, because I think you believe more in the national proceedings, right? I mean, I'll let, if you want to elaborate on that, and then I'll come back with an elaboration of another angle, maybe.
Yeah, so certainly I think that international institutions have a role, but I've long argued for a bit more of a softer view of complementarity. You know, it's a bit more qualified, that would allow national institutions that don't exactly mimic the procedures of international institutions to have a little bit more airtime. But I was also sort of just listening and thought that in the spirit of an optimistic conversation about crisis, I think we've spent some time on the critique side, and that's important. But, you know, so what's something we can celebrate, right? What's something that's good? What do we think so far is a positive contribution that the 20 years of the ICC and longer in terms of other institutions have done? And I do see some positivities. One that I see is what I would call communitarian regrouping. And what do I mean by that? I think these international criminal justice institutions, to some extent, have brought us all closer together. I think they've obliged us to share a common vocabulary and express ourselves within that particular frame. Express our wants, our desires, also our embarrassments, our hesitations, and our reluctances within a common shared language of avoiding impunity, commonly defined words that describe what are now commonly understood crimes. It's given us a space where those who are avoidant have to justify their avoidance, and those who are enthusiastic can push forward for their enthusiasm. I think that's very important. The global community has not had that before when it came to things like atrocity. In the past, you committed atrocity or you were a war criminal, you were just ugly or unpleasant or defending the nation or a loser in war. Now you have to speak about yourself and be spoken of in the language of you're a criminal. So I think there's been a communitarian vocabulary that has emerged that has created conversations that didn't exist before. I think that's good. I think another thing that is positive that international criminal justice institutions have done, and this riffs off of your point of the expressive value, I think that these institutions, through their work, however selective, however overambitious, however unsatisfying, however expectation falling, have surfaced a lot of information about terrible things happening in places and have given a vector for some level of surfacing, dissemination, and knowledge production. And it's become harder, especially coupled with social media, it's become harder to hide. It's become harder to get away with something that all of us find reprehensible, and that is getting away with doing ugly things and not being spoken about, not being noticed, not being seen. And I think those are two important positivities. And the third comment that I would make is, just like one can critique the international criminal justice institutions, I think one can also critique the critics. And I think as someone who's been a critic of international institutions, I also hope I have some self-awareness, and I also hope that I have some, I don't know if modesty is the right, I don't think I'm modest, but some level of critical perspective of oneself. And I do think an important point to make is critics are often very impatient. We are very impatient. And we just celebrated Martin Luther King Day here in the United States, and you know, one of his most elegant quotes is the idea that the arc of justice is long, but it always bends in the right direction. And I think it's important to recognize that. We're very impatient because our lives are too short and our time is too rushed. But in the arc of human history, a lot has been accomplished in the past 70 years, in the past 30 years, a lot. And I think at a certain level, we should also be proud of that, right? So I spoke earlier of you know, penguin steps and penguin shoes and belly dancing and awkwardness, you know, and our moods, and our tides and our moods, they come and go like in a Cancerian sense, like in an astrological sense, we're on Earth in junction with tides on the moon and back and forth. And sometimes we get really down. And I think that's normal. That's part of the human condition. But I also think sometimes you should take a step back and say, look, there's a lot more work to be done, but we've actually done a fair bit. And some of it's been sloppy, some of it's been unsatisfactory. But I also think it's important to recognize those. On the other hand, I think it's problematic. And I think a lot of experts in any discipline are like this, and law is no exception. Once you're in this bureaucratic sense, a particular niche of market expertise, in this instance, international criminal law, people often become very territorial, they become very defensive, they become very sensitive. All experts are like this. Because if you invest so much in your expertise and someone challenges it, then you're left with little or nothing. You can look like a fool. And I think that also needs to become overcome. I think that a maturity and a modesty is important in this regard. So there's also lots of positives, but it's not enough. That's what I also think.
Yes, I agree with that, and I will say something else though in terms of international, you know, interventions and so on. National courts are starting to conduct various trials, not starting to, they've been doing this obviously for decades, but you know, in the aftermath of what's happening, or still what was happening, what is still happening in Syria, and in response to the fact that there's complete political stalemate, and it's very difficult to move in the way that's been done before, right? So it's not impossible to do things, but it's impossible to do them the way that they have been done before, which has now caused new things to happen, right? It has caused much more universal jurisdiction cases to come online than have done in the past couple of decades. It has resulted in the General Assembly for the first time creating a mechanism to collect evidence. So it has brought about a number of positive developments out of what is a very dire situation where there's, you know, we've all been witness to 10 years of atrocities that nobody's doing anything about, basically. But what this means is that now we have to look at how these courts are able to perform that function, because they are even more limited. I'm talking about explaining their work and communicating their work to the people who are most concerned. Because if you look at what was happening in the most recently concluded trial in Koblenz, people in Syria wouldn't have had a clue as to what was happening in the trial itself, were it not for a number of NGOs and independent lawyers who put things together, a very important podcast and a very important summaries of proceedings that they put online. None of these were done by the criminal courts themselves or by the authorities in Germany, because they were acting in accordance with their own criminal procedure laws, which do not require them to particularly do any kind of outreach. And so this is now an important thing to take into consideration, because all of these positive developments need to be also looked at critically, need to be analyzed for their shortcomings, need to be improved upon, because that's not, in fact, so difficult to do in terms of at least this particular area. We also need to look at situations where there are still countries where national judicial authorities are unwilling or unable, or both, to conduct certain proceedings where an international intervention might still be needed, right? Because what we're looking at, for example, Lebanon, a great example, the massive blast which occurred in Lebanon, which, without going into any analysis of how the investigation is being conducted, because it's very difficult to comment on an ongoing investigation in absence of confidential, rightfully confidential information. But what we see is a political deadlock where the government hasn't convened for 3 months because some parties are interested in or demanding that the investigative judge be dismissed. The second one. So quite clearly, there's something wrong, and it requires an international intervention if it's ever going to move forward. That much is clear at this point. What kind of intervention, that's a different issue. But certainly there's room certainly we can conclude that locally nothing will move in the right direction anytime soon. And this is just one example. Again, there's many, many others. So I would definitely echo that we have come a long way, but also argue that, first of all, the ICC is not the be all and end all. The ICC is a very important institution which should be empowered to do its work, which should be supported in doing its work. It should also, as you mentioned, own its own challenges and its own successes in a way that it perhaps doesn't at the moment. But I believe that we will probably also see other ad hoc efforts, be it international investigative commissions that then lead to perhaps some national proceedings, be it universal jurisdiction cases, be it other different ways in which criminal justice will take place. And I certainly hope that we will have many more efforts which are not only criminal justice efforts, but more holistic approaches to dealing with atrocities and their aftermath.
On the topic of universal jurisdiction, and I see a question in the chat from Rohan, is international criminal justice system is West-based. So I think an interesting thought puzzle that could actually become put in practice is, when it comes to universal jurisdiction proceedings, and the Germany case stands out, it's generally courts in the global north that are serving as these universal justice receptacles, right? I think it would be really interesting to create an international system that was truly cosmopolitan. And if courts in certain states in the global south would be up and willing to provide the resources for universal jurisdiction proceedings to take place in the global south that involves violences committed in the global north, for example. I think we can do a lot more with where universal jurisdiction proceedings are cited with an S, not with a C, right? And I think citing them in jurisdictions all over the world, including throughout the global south, would allow international criminal law to have a better citing with a C, namely a broader variety of citations for many, many different jurisdictions. So I would really love to see a universal jurisdiction system that focused on prosecuting crimes in the north, or crimes anywhere, in court systems in the global south, and specifically earmarking funding for that. And perhaps that could also have a broader spillover effect on building national judicial capacity. So that's one recommendation. That's one recommendation that I might suggest. I think another point that I would make that I think could bring some greater level of positivity to the overall frame would be to detach the reparative function of the International Criminal Court from its retributive and punitive function. I think the reparations proceedings at the International Criminal Court, however informative, however aspirational, however they may have expiated and diversified the justice function, still operate within this hierarchical frame of reparations as subaltern to retribution and penal sanction, when, at least from my experiences with victims, reparations are very, very important. We have an international criminal court. We don't have an international truth commission. We don't really have an international reparations function. We don't have an international commemoration function. And I think instead of trying to cram all of this stuff within the framework of the Rome Statute and the International Criminal Court, I would love to see more institutions populating the international space. I do have a preference for more things at the national level, but that's not unsympathetic to or incongruent with a perspective that suggests we should have more internationalized institutions. So those are two much more specific reforms that I would suggest.
Thank you, both of you. I think we can now go through some of the questions that we received in the chat as well. So one of the first questions we received was from Emilia, who is from Colombia. It's about the expectations that we have about the ICC. So the question reads as follows. I just wanted to note that expectations may also depend on what the definition of international justice or justice itself is. How would you define international justice? Is it different from the concept of justice itself? Maybe we should have started by that. Who wants to take this one?
Mark, do you want to take that one?
Well, I think one of the major concerns that I would have along these lines is what so far has international criminal law criminalized, right? What is part of the language space? And in general, rooting off of the beginnings in the Nuremberg proceedings, it's massive violations of civil and political rights, and its harms suffered by human beings. So even in the Al-Mahdi case, which involved cultural property destruction, which is a theme that I find quite interesting, the locus of the harm was in the value of the property, the mausolea, to people, right? In light of their religious persuasions and devotional purposes. I think the definition of international crime is lacking in two major areas. And the first is an insufficient attention to economic and social crimes that in many, many ways affect individuals often as profoundly as physical violence might, and certainly not to the point of exclusion. And secondly, I think when I look ahead, I mean, I'm not young anymore, tragically, but I'm not, life happens. But, if I look at future generations looking ahead, I think that the major human rights, stability, sovereignty, and integrity challenges that future generations are going to face are going to involve environmental cataclysm, and public health concerns. And I think this presents an enormous challenge for criminal law. So one response to this push towards recognition of the major effects of climate change and environmental destruction is this conversation to include ecocide in the frame of the International Criminal Court, or penalize ecocide, and also to build a bit more on the war crime that exists in Article 8 of the Rome Statutes of long-term, severe, etc., harm to the environment. But the percentage of global environmental destruction that is brought by the kinds of intentional conduct that comprise ecocide or a war crime of environmental destruction is minute. It's infinitesimal. It's barely nothing. If we look at the major threats going ahead of environmental damage, climate change, and pandemics, they are not created by individual mens rea conduct. They are not triggered by discriminatory animus. They're not of the mental intent that is generally required for the kinds of civil and political rights violations that fall within the frame of existing international criminal justice. The harms of climate change and pandemics generally arise through ignorance, poverty, lack of resources, carelessness, thoughtlessness, negligence, inadvertence. And if those are the major challenges that younger generations face, I think international criminal law has to ask itself whether what we're currently litigating, what we're currently talking about, is truly and will truly remain the greatest concern of the global trust and the greatest ways in which the global trust is going to be busted. And I think this presents a real challenge to law, because I'm not certain that a penal-based criminal law is going to be the way to attenuate, mitigate, eradicate harms that are environmental and public health and tied to global flows of capital. So I think this is another interesting challenge, and I'm sorry for going on a bit, but that was my kind of response to what is international justice. I also think we need to recognize that for young folks today, what we're talking about now really matters, but other stuff matters a lot too, and it's not a good fit with penal law. I mean, unless you're going to criminalize people who slash and burn forests in the Amazon to survive, unless you're going to criminalize people who, take an airplane too much, unless you're going to criminalize a community that builds a factory. You can't do that. That's total over-criminalization.
Thank you, Mark. Next, we have a question on the Q&A function, this time for Olga. With the current funding situation in STL, what future do you see for the justice there?
Interesting question. I left the STL over a year ago, so I can't really speak in great detail. What we have seen is a travesty. I cannot actually put a better word to it, where funding was dramatically cut. So much so that it led to the cancellation of the STL second case. Case of the Hariri assassination. So that case will be concluded for the time being, because as everybody knows, the trial was conducted in absentia, which means it can be repeated if the accused or convicted person is ever apprehended. So, but it will conclude for the time being. However, the second case was canceled, and that is a travesty. That also exposes some of the problems that we hadn't perhaps touched upon as much, which is the structural issues around international criminal justice, particularly this move towards voluntary funding, which has happened in the case of the Sierra Leone Tribunal, in the case of the Cambodia Tribunal, in the case of the STL, which has led to dramatic problems. I mean, the Sierra Leone Tribunal and the Cambodia Tribunal had gone through periods of insolvency and come out the other end, and the STL not. I mean, the STL, for example, has completely discontinued its entire public information department, not just outreach, but public information. They do not have a spokesperson anymore. And this is a complete move backwards in violation of every rule in respect of what these organizations are expected to do. So the STL, unfortunately, has been the victim of this very, in my view, inappropriate way to fund institutions, which is through voluntary contributions. This is not an appropriate funding model for international justice. Even if there were no problems such as there are, you could still speak about the issue of the problem of perception, because people can legitimately ask who's funding, why are they funding, why do they have an interest to fund, again, if it's based on voluntary funding. That said, what I wish to also emphasize is that the judgment that the STL did issue is an incredibly important document. And hopefully the appeals chamber judgment will be an addition to that, to completing the understanding of the situation. But this is something that unfortunately has also been, there's an American expression, which I'm not sure translates very well in other languages, but it is throwing the baby out with the bathwater. So with all the criticism that has been leveled at the STL, rightfully, for what has happened with the funding, for the fact that the proceedings did take a long time and so forth, people have also neglected the actual outcome of the trial, which is unfortunate because the judgment itself is hugely important, first and foremost for people in Lebanon, but not only for people in Lebanon, and for anybody who's interested in the region, the power dynamics in the region. A lot of that is reflected in the judgment. But unfortunately, the STL at the moment cannot be used as a brilliant example of what international criminal justice was meant to achieve.
Thank you, Olga. Next, I see one hand raised by Samuel Oyonge. If you want to take the floor, you can unmute yourself and ask your question.
Thank you so much. I'm from Kenya, and I want to first of all appreciate Ms. Olga and Dr. Mark. It has been quite enlightening. I don't have a law background. I'm actually a scientist, but I am quite dynamic. And my question, it's quite wild, and I direct it to Dr. Mark. What I have observed honestly over the years, though I'm quite young, is that the problems we are currently facing are actually more hereditary in nature, meaning we have inherited these problems from our forefathers. And I'm trying to imagine whether this is actually the course we want the future to take. And for this, I was imagining, what is the possibility of having a wild concept like global pardon or universal pardon, an initiative that is aimed at making the justice system begin on a clean slate, which will involve forgiveness of all people, and then beginning the process again, basically cutting off the present future from the bad mistakes that our forefathers committed. Yeah, thank you.
So I think that's a very, very interesting question. And this idea of tabula rasa, wiping the slate. So in medieval Europe, and I don't remember which French king it was, but at one point there was an edict, the Edict of Nantes, and it simply said, all the heinousness that has happened in the past is finished now. It's simply going to be forgotten, and we're going to move on. Now, it didn't work because conflict between England and France just continued endlessly thereafter. But it's an interesting thought experiment, this idea of a reboot, but a real reboot, like just tabula rasa. So it's an interesting thought experiment, but it is something that law would find deeply inimical and inappropriate. Why? Because international criminal law is predicated on two major assumptions. One is, the amnesty and forgiveness is unacceptable. And the other major predicate of international criminal law is that vengeance is unacceptable. So two of the most profound human emotions throughout all of history, forgiveness and forgetting, denialism, is off the table. And the other human emotion, vengeance, is off the table. And what we have structured as the way forward is that evil should not be forgotten and justice should be sought through the courtroom, or these kinds of procedural mechanisms. And I think there's an intrinsic danger to tabula rasa, and I think there's an intrinsic danger to vengeance. So it's hard to quarrel with the international criminal justice approach. What I also find interesting in your remarks about this hereditary nature is I would really like to see, and this brings me back to some of the environmental comments that I made a bit earlier. What I would like to see is a greater development intellectually in our imagined space of what I would call intergenerational equality. And this goes back to, core philosophy, Plato, the allegory of the cave, John Rawls, and the veil, right? This idea of, should we construct a world based on an absolute lack of knowledge of who we may be in that particular world, where we're born, what species we are, the time in which we're born. Perhaps the greatest justice would occur if we all had a veil of ignorance and we didn't have any personal skin in the game in the institutions as we're building them. Now, what I would find very interesting on this front in a practical sense would be the development of deliberative institutions that actively had real-time representatives that would real-time represent what they conceptualized as the interests that the unborn would have, that people born in 50, 100, 150 years, 200 years would have. And sure, this may sound like crazy talk, but it's not. Because at the end of the day, one of the greatest inequities that we have is that those to come are so vulnerable to those that are now. And I really wonder what a system of international justice would look like if at the table were representatives in real time sworn only to represent the positions of those that are not yet born. And I wonder what that would look like. And I would suggest there will be far greater attention to economic, social, cultural violations, poverty, capitalism, and environmental and pandemic concerns. And to me, that would be a more just conversation. Thank you for your question.
Interesting point. We have seen that actually, but not in international criminal justice, but with the climate change cases that were brought about, by people representing the interest of children, and those who are yet to come, which is a very interesting point. Just one other to what you said, something that you said earlier, which really resonated with me, which is that international crimes present a hierarchy of crimes which are very important. And so people seek, and we've seen that again, going back to the example of the Beirut blast, many people in Lebanon said, this is a crime against humanity, right? And so lawyers have, lawyers and legal scholars are going out of their way to explain why that's a bit of a, dubious position in terms of the law, but you can understand that that's exactly where it's coming from. It's coming from the realization that even if somebody isn't ultimately held responsible for the blast, it may very well be negligence. Mm-hmm. Just plain and simple negligence, which carries a sentence of 3 years in Lebanon. Right. Well, and this really speaks to the point that you made a little bit earlier about this creating this hierarchy of norms that may not be appropriate for the moment we live in now, and certainly for the future moments where things will not be necessarily, the worst things will not be caused by genocide, crimes against humanity, as we have defined them up until now.
Well, and also we've created a hierarchy among perpetrators and who is responsible. And we've put the individual in that particular space. That decision was deliberately made in Nuremberg to hold individuals responsible for crimes of state that were crimes of hate. and to really spare corporate or institutional responsibility. Yes, there's some space for reparative justice in that particular arrangement, but when it comes to penality and criminality, culpability rests in the individual. I think one of the best things that could happen in the global justice space is for corporations to be determined to be persons, and somehow to be put in a place where there can be penal responsibility without all of these layers of insulation. But that's not going to happen through the ICC. In fact, international criminal law has been incredibly unsuccessful at corporate criminal liability. And in fact, when that was on the table, here are these strange externalities. You know, in the United States, an alien tort statute litigation that can involve corporate responsibility for individual wrongdoing, the United States Supreme Court decided that corporations can't be responsible for international crimes. And one of the pieces of evidence they relied on, and justifiably, was that all international criminal justice institutions don't permit criminal responsibility for corporations. So why should American national courts do so? The only one that flirted with it a little bit, actually, Olga, is the STL that actually had some kind of conversations in this space. So that is a problem that international criminal law has failed at dealing with. The only redress for that problem is to try to minimize globally limited liability of corporations, which is a central element of capitalist economic structures, for corporations to be constructed as persons. That would have a sea change, I think, in accountability conversations. But international criminal law gave up on it. Why? Because we wanted the institutions, we wanted them quickly, we wanted to celebrate on July 17, 1998, and conversations of corporate criminal responsibility under the Rome Statute would have scuttled the entire project. So we dropped it. That's a missed opportunity.
Thank you, Mark and Olga. We don't have too much time left, so unfortunately we won't be able to address all the questions, but I would suggest to at least answer one more and then see if we still have more time. So the next question is on the Q&A, a question from Jusqu'Ael Dukunda. I'm sorry if I mispronounce your name. The question is the following. According to the complementarity in the international criminal justice system, what do you think of the arrival of the African Court of Justice and Human Rights? Do you see this as an advance that could benefit the complementarity in international criminal justice, or could it create overlap between the two courts?
Well, interesting question. It's a bit difficult to speculate, actually, because it remains to be seen what kinds of cases it will concern itself with. I think that, in my view, I think it's a positive if we're looking at regional efforts. But again, this is just on a very theoretical level. I think that answer can rightfully be provided perhaps when we see some jurisprudence. I do not think that it's an inherent problem. I do not see it as a priori problem at all, because I think that these institutions can certainly coexist. And I think it's good to have a regional effort in Africa to deal with regional local issues.
Thank you, Mark. You want to add something, Mark?
Yeah, very quickly. You know, it's hard to disagree with that. I do agree, and you know, time is running out. But I see a question in the chat, and it relates to atrocity, COVID, and responsibility. And to me, these are important conversations, because COVID truly is an atrocity that has resulted in a lot of death. And I think this is a crisis that should really get us to think about the amount of efforts and time that the International Criminal Court invests in prosecuting what it is doing. And are we really entering a space where all of this effort isn't on target with the major stability, security, and human rights concerns of the future, which do, in my view, involve pandemics, climate change, and the environment. And I think that's a really, really important question.
Thank you. Thank you, Mark. So we are running out of time. We won't be able to address more questions, unfortunately, but I would like to thank you very much. First of all, our two experts, Olga and Mark, for this insightful discussion. It has been a pleasure listening to both of you and learning from you as well. And thank you everyone who participated in this webinar and for your insightful questions as well. Please don't forget that if you want to continue this discussion, you can join our upcoming Executive Diploma on International Criminal Law and Transitional Justice. In a follow-up email, we will be sharing both the recording of this webinar as well as some useful links if you are interested in. And thank you again. I wish you a great rest of the day, and I look forward to welcoming you for other webinars and training programs.
Thank you very much. And thank you all for listening and your questions.
Thank you and be well.